Hello friends, I am Arpit and I am here with today's analysis. Today is 30th of September and we are going to deal with one very important topic from UPSC prelims as well as mains perspective. That topic is a law which has been controversial since its inception, a law which has been necessary also since its inception. This law was passed in the year 1958 specifically to tackle the insurgency-like situation in the northeastern states, specifically Nagaland. Yes, this law is none other than the Armed Forces Special Powers Act. We know it by this name ASPA. In this topic, we are going to cover the basic details of ASPA, the basic provisions of ASPA, what are armed forces, what are kind of special powers, where are these special powers available to them. Then we will also be looking into various recommendations with respect to this law, because since its inception various committees have been formed, they have given their judgment with respect to this. We will also be looking into Supreme Court judgments. Supreme Court has given a few judgments with respect to this law, and this actually is going to be our content in today's session. We should also understand one thing, that Armed Forces Special Powers Act is basically a law which gives special powers to the armed forces to tackle terrorism, insurgency, these kind of situations. And since we are covering Armed Forces Special Powers Act today, we will be covering tomorrow another very important law, that is Unlawful Activities Prevention Act. These two laws are said to be the two laws framed by the government for tackling situations like terrorism, insurgency, militancy in the country. And these two laws are very, very important from exam point of view. UPSC has asked questions directly based on these laws in the mains examination. And we will be, decoding them, simplifying them for you and putting it in front of you, and you'll get a holistic understanding with respect to these two laws. So today, ASPA, tomorrow UAPA, that is Unlawful Activities Prevention Act. Now, the Armed Forces Special Powers Act. When I talk about the origin of this act, it was first formulated by the Britishers in 1942 during the Quit India movement. So it would be right to say that it is also a British legacy. There, armed forces were given some special powers to arrest the people, to kill the people without warrant. And then, when disturbance happened here post independence, actually the disturbance in Nagaland started right away in 1947 only, but it was 1958 when the central government decided that we need to adopt this kind of a law. We need to give some special powers to the armed forces who will be deployed over there. There means disturbed areas. So a disturbed area has to be declared first, and in that disturbed area, when the armed forces are being deployed, they will be having special powers. Special powers to arrest someone without a warrant, to kill someone without a warrant, to search the belongings of someone without a warrant on the basis of suspicion, to destroy any arms dump which has been discovered without any permission, right then and there. These are some special powers. But after the assumption of these special powers by the armed forces, these special powers were misused also by them. And that is why this law has become controversial. There have been many instances, like there's one lady known as the Iron Lady of Manipur, Miss Irom Sharmila. She was fasting for multiple years for this particular law or against this law. In Manipur only, there was this Mother's Nude March which happened against this law, where a few females, they went out naked on the street because they were fed up of the atrocities done by the armed forces deployed over there under the protection of ASPA. Many rapes have happened, many extrajudicial killings have happened, encounters have happened, and there was this blanket immunity given to the armed forces personnel. So they were doing it because they had this special powers with them. But later on, as time progressed, and I think it was 2016 when the Supreme Court decided that blanket immunity should not be there with the armed forces personnel. Every death whether of an insurgent or a non-insurgent person, done by these armed forces personnel in a disturbed area will be inquired into. And if it happens to be a person, after the inquiry, if it happens to be a person who was not related to any of these kind of activities, then there will be strict action against the armed forces personnel. So this kind of check was put by the Supreme Court on the armed forces. This act is still there. In Manipur, the entire state of Manipur presently is under this act. Earlier it was not. I think by late 2022 or early 2023 also, ASPA was not extended in the entire state of Manipur. Some areas were, devoid of it, or in some areas like the capital, Imphal municipal area and all, it was not implemented or it was not applicable. But now, since Manipur is entirely disturbed, so in entire state it is there. Apart from Manipur, it is also there in Arunachal Pradesh, Assam and Nagaland. So these four states of Northeast India, not entire of these states, a few pockets. It gets reviewed every 6 months. And there's a separate Jammu and Kashmir Armed Forces Special Powers Act which got passed in 1919 that was specifically for the state of Jammu and Kashmir. So there are two AFSPAs. One is AFSPA, Armed Forces Special Powers Act 1958, which is presently there in 4 states of Northeast, but it can be there in any state of India. And one got passed in 1990 that is specifically there for the state of Jammu and Kashmir. That is Jammu and Kashmir Armed Forces Special Powers Act. So let's get started and let's get into the details of this particular law. Now, when I talk about the origin of this act, it got inspired from a British era law which was passed in 1942 during the Quit India movement. This particular law gave Britishers extraordinary powers to arrest Indians, to kill Indians, to search the belongings of the Indians, because Indians were protesting, Indians were doing this movement to send the Britishers. The act came into force in context of increasing violence in the northeastern states in 1950s, the present act. And finally, on September 11, 1958, this was approved by the President of India, and Armed Forces Special Powers Act 1958 came into existence. Now let us see some definitions in the Armed Forces Special Powers Act. First of all, who are the armed forces? Is it including the army? Is it including the Central Armed Police Forces? Does it include the state police also? The answer to these questions is that it includes, or it can include, any force of the center. Now center is having control over Army, Navy, Air Force, Indian Coast Guard. These are armed forces. Then there are CAPF, Central Armed Police Forces. Those are also under the center, like CRPF, Assam Rifles, ITBP, or we have CISF, NSG. There are 7 such CAPFs which are there. So any forces of the center deployed in disturbed areas will be having this special powers, not the state police. This should be understood very clearly, that the state police does not come under armed forces for the Armed Forces Special Powers Act. Disturbed areas, second, because this armed forces will have the special powers only in disturbed areas. They cannot have this special powers all across India. If entire India is declared as disturbed, then that is a different thing. But yes, it has to be applicable only in disturbed areas. So what are disturbed areas? We should know that as well. So Article 3 of ASPA defines disturbed area as any region which is disturbed due to reason of differences or disputes between members of different religious, linguistic, regional or caste communities. This is basically the definition of disturbed areas, and Manipur presently is a disturbed area because yes, there is differences between two communities which can be considered as ethnic communities. So that is basically there. Now what are the special powers? Now we've come to know armed forces, we've come to know disturbed areas. These special powers are available to the armed forces in disturbed areas only. So let us know what the special powers are. Any commissioned officer, warrant officer, non-commissioned officer or any other person of armed forces of equivalent rank. Means it is not available with everyone. Only specific rank officers are possessing these special powers. Now, what are these special powers? After giving due warning, that person can fire upon or otherwise use force even to the causing of death against any person who is acting in contravention of any law or order for the time being in force. So, can use force up to and it can cause death also. That is the special powers. Arrest without warrant, destroy any arms dump or destroy the fortified positions and shelter. If let's suppose any arms dump is recovered by the armed forces, that has to be destroyed. Else, in normal situations or in non-disturbed areas, what is the protocol? If you discover any arms dump, you have to showcase it to the press and then you have to submit it to the artillery house of the armed forces. So that is the procedure. But here you can destroy it. Enter and search the premises, including vehicles, over the suspicion without warrant. So premises search, vehicle search without warrant can be done. You don't need to have a search warrant. The big question, or I would say the biggest question with respect to this law is that, is this law needed? You might be seeing, sir, so much special powers. These special powers can be misused, and they have been misused. And now think, is this law needed? I would say that yes, it is needed, and I would say no, it is not needed. Yes, it is needed for maintaining the security of the country, for upholding the, I would say, integrity of the country. These kind of special powers are needed to punish the people who are, destabilizing or trying to destabilize the, I would say, integrity of the country. No, it is not needed when the members of armed forces, they are misusing it. So we will look into both these arguments, yes and no. This law is needed, why it is needed. This law is not needed, why not needed. Arguments in favor: provide more power to the armed forces to perform their activities to restore to the situation to normal situation, because this Armed Forces Special Powers Act is available to the members of armed forces in disturbed areas where situation is not normal, and to make the situation normal, certain extraordinary powers have to be given, and that is why it is given. If ASPA is prematurely withdrawn in security situation, in those disturbed areas, the security situation will deteriorate and will take more time to restore peace over there, because disturbance will keep on increasing. There will be no check on the insurgent activities or the militant activities. So this is the reason. Law codes, IPC and CRPC, we have two law codes, Indian Penal Code and Criminal Procedure Code, which are going to be changed according to certain amendments to these laws, both of these laws which have been tabled by the Parliament in this monsoon session. But anyways, coming back to this, they provide limited power to the armed forces to deal with these kind of situations. So there is a separate law. That is why it is needed. In disturbed areas, the involvement of proxy groups are there. Proxy groups, basically those kind of groups which engage in proxy war. Proxy war means you will not know who is an insurgent or who is a militant, but that person is engaged in those kind of activities. So in that case, you need certain extraordinary powers. You need to search that person. You need to search the belongings of that person. You need to use force against that person if that person shows resistance. And all these powers are special powers under ASPA. So to tackle these kind of, I would say, people, proxy groups who are engaged in proxy war like situation, because insurgents, militants, they are all engaged in proxy war. So these kind of special powers are required. Then effective functioning. It is important for effective functioning of the armed forces, because in case of insurgency and militancy, these are grave problems or grave situations. So these armed forces people will have a sense of security when they have ASPA with them. They know that they have some special powers. There will be this sense of security, and this sense of security will lead to effective functioning. Security of the nation. Provisions of this act have played a crucial role in maintaining law and order in disturbed areas, thus protecting sovereignty and security of the nation. That is again important. Protection of members of armed forces. They will have these powers. So this point, effective functioning and protection of members of armed forces by giving them some extraordinary powers, are related to each other. But yes, it is important to give them sense of protection also. And these are all the arguments which are in favor of such kind of a law. Now let us look into the arguments against. As UPSC aspirants, we should know both the sides of the coin. So first is misuse of provisions of acts. This has led to fake encounters, extrajudicial killings, disappearances, etc. And these are some common, I would say, phenomena in Jammu and Kashmir, northeastern part of the country. Hence, ASPA is described as draconian, repressive, colonial and archaic law in the Indian democracy. Supreme Court itself has described it as a draconian law. But side by side, Supreme Court has said that we need such kind of laws also, because to maintain the security of the country, to give the armed forces a sense of, I would say, security or a sense of confidence, we need such kind of laws. That is why this law is continuing from 1958 till now. Then ASPA can be seen as violation of all other constitutional rights like prevention against arrest, detention, privacy, because anyone can search your belongings, anyone can arrest you. Anyone means the armed members of armed forces can arrest you without a warrant. So these are against your fundamental rights. Human rights violation in ASPA areas are not inquired into and followed by adequate action. So they had immunity. Thus it is against the principle of natural justice. But now since 2016, Supreme Court has said ki, every killing will be inquired into. But what if not killing is not there, but atrocities are there, like rape, the armed forces personnel are raping, then that kind of, I would say, activity will not be inquired into, or they are just, beating you, that kind of activity will not be inquired into. They are arresting you without warrant, they are searching your belongings without warrant, that kind of activity will not be inquired into. So that will basically create problems. Then second is diminishing credibility of democracy. Now, how credibility of democracy will get diminished? Now, the people in disturbed areas, the common people who are at the receiving end of this law, they think this way, that if democracy has given us laws like this, then democracy is definitely not good. And that is why democracy's credibility is getting diminished. So this is one of the major, I would say, drawbacks of this kind of law. It is ineffective. One argument is that if it would have been so effective, then it would have tackled insurgency and militancy, because in insurgency areas it is there since 1958, Nagaland, it is still there and it is not able to wipe it out. In Jammu and Kashmir it is there since 1990, still militancy is continuing. So if this particular law was so effective, then those problems would have been tackled, no? This clearly points out towards the fact that it is ineffective. Now, where is ASPA presently applicable? As I mentioned earlier also, now I will also be mentioning that ASPA basically is implemented in 4 states of Northeast. And when I say 4 states, not the entire states compulsorily. Now Manipur, entire Manipur ASPA is there. In September 2023 only, the state government has notified it to be in the entire state, because entire state Manipur is disturbed presently. But yes, some parts of Assam, Nagaland are disturbed areas, and every 6 months revision keeps on happening. So since April 2022, the same areas in Assam and Nagaland are under ASPA, are disturbed areas. In Arunachal Pradesh, disturbed areas notification is confined to districts of Tirap, Changlang, Longding and the areas falling under Namsai and Mahadevpura police station bordering Assam. So these are there. So these 4 states in Northeast India, apart from Manipur, in all these 3 states, it is in some parts applicable. You don't need to memorize which part in which state ASPA is there, because UPSC will not ask this question. Every 6 months it gets updated. But yes, if ASPA gets withdrawn completely from any state, that becomes the news. So currently these 4 states, some part or the other, ASPA is there. ASPA 1958 is there. And in Jammu and Kashmir Special Powers Act, Armed Forces Special Powers Act 1990 is there. Okay. So these are the 5, I would say, regions in which ASPA is there. Now observations on ASPA. When I talk about observations on ASPA, there have been various committees which have recommended, and the first committee which we are going to pick up is the Vajirao and Reddy committee. He recommended abolition of ASPA. ASPA should not be there. He said that a comprehensive arrangement can be made under UAPA, that is Unlawful Activities Prevention Act. This we are going to cover tomorrow. So this is also another law by the government which is for tackling, activities like terrorism and all. Then only commissioned officers can order use of force if he/she feels necessary. Each district should have a grievance cell. Grievance cell basically is that cell in which people can go and file complaints if they have any with or against the members of the armed forces. This cell should be independent and competent to inquire into violation of the rights of the people. But none of them have been followed. Justice Santosh Hegde committee, he also termed ASPA as symbol of oppression. It should not continue. Abolition, symbol of oppression should not continue. Let us see more. The Justice Verma committee. Justice Verma committee was formed in 2012 after the Nirbhaya gang rape case. This particular committee was for amending laws to improve female safety or women's safety in the country. And he also talked about ASPA. Now in ASPA, it is not like the inquiry cannot happen against the armed forces personnel. It can happen, but for that inquiry you need prior permission of the central government, because these forces are of central government. If the central government permits, then only inquiry can be initiated. Now what Justice Verma said, he said that if an armed forces personnel is engaged in a sexual offence, if that armed forces personnel, let's suppose, has raped some female over there, then in that case, if you have to do the inquiry, you don't need to take permission from the central government, because that does not come under the ambit of special powers, raping someone. This was the recommendation of Justice Verma committee. Then the second ARC report, Administrative Reforms Commission, which was rolled out in 2005-06, this 5th report has recommended repeal of ASPA. Again, repeal of ASPA. So many committees recommending repeal of ASPA. Earlier, Vajirao and Reddy committee, then Santosh Hegde committee, and now this 2nd ARC report, 5th report of this 2nd ARC, repealing of ASPA. Justice Verma committee did not recommend repeal of ASPA, but yes, it said that in case of a sexual atrocity or sexual violence done by the members of armed forces, prior permission from the central government for seeking an inquiry into or starting an inquiry should not be there. Let us also look into the Supreme Court's viewpoint. Now in Supreme Court in 1998, there was a case called as Naga People's Movement of Human Rights versus Union of India. Now these Naga People's Movement of Human Rights, they filed a case in the Supreme Court challenging the constitutionality of ASPA. Constitutionality, how they challenged? They said that maintaining law and order is under the ambit of state government. ASPA is for maintaining law and order. Why the central government has passed this law? This law should have been passed by the state government, and that is why we challenge the constitutionality of this particular law. The Supreme Court dismissed their plea and said that Armed Forces Special Powers Act is definitely for maintaining the law and order, and the law and order situation in the disturbed areas is having clear-cut connections from across the border. So it is about, international security, or it is about, safeguarding India's territorial integrity. Hence, the central government is allowed, because Nagaland wanted to secede from India, wanted to carve itself out from India and form a separate country. That is why those disturbances were there, and to tackle those disturbances, ASPA was passed. So it is the duty of central government to maintain national integrity or territorial integrity of the country. So central government has passed this law correctly. It is not unconstitutional, but however, the Supreme Court said that few, guidelines should be met. So it arrived at certain conclusions. First was a suo motu declaration can be made by the central government for, ASPA, but it would be desirable that state government should be consulted by the central government before making the declaration. Second, ASPA does not confer arbitrary powers to declare an area as a disturbed area. There should be some logic and rationale behind that. The declaration has to be for a limited duration, that is 6 months, and that is why I am saying that after every 6 months it gets updated, because it is according to this particular judgment of Supreme Court in 1998. Now, while exercising the powers conferred upon him by ASPA, the authorized officer should use minimal force. The commissioned officer, non-commissioned officer, whichever is deployed over there, should use minimal force necessary for effective action. And the authorized officer should strictly follow the do's and don'ts issued by the army. So these were some of the guidelines, I would say, issued by the Supreme Court. But yes, most of them are, it should be there as far as possible. All these kind of words were used. Nothing was made mandatory on the central government or on the armed forces. So, but yes, the central government respected this guidelines and at least adopted this 6-month rule. Now the state governments are also taken on board while deciding upon ASPA. So the present extension of ASPA in Manipur is declared by the state government of Manipur. So this is actually how ASPA or central government is respecting the federal structure. The 2016 judgment. Now what happened in 2016? Supreme Court was hearing a plea demanding probe into 1528 deaths alleged to be fake or extrajudicial encounters by the armed forces in the state of Manipur. These many deaths happened in the state of Manipur in 2015. So there was a case, with respect to these deaths in the Supreme Court. And then the Supreme Court ruled that deaths caused by armed forces in a disturbed area involving either a common person or an insurgent, whoever is dying, that particular activity of the armed forces of killing those people should be thoroughly inquired into so as to find out whether the killing was extrajudicial or not. This clearly meant that no absolute immunity for armed forces personnel was available who commit such a crime even in a disturbed area. So that was some of, I would say, a breather for the people over there. Now at least inquiries will happen on deaths. But what about non-deaths like rapes and all? There the inquiry will not happen. So this was there. Now the conclusion, if I talk about, actually this law is needed to tackle the proxy situations over there, proxy war-like situations over there in those disturbed areas. This law is needed, but there is no need of ambiguity in that law, first of all, and there is no need of, I would say, misuse of powers under that law. Anyone who is misusing the powers should be strictly punished. And that person, whether belonging to any armed forces, the Central Armed Police Forces or the Indian Army, anywhere. Because above all, we are humans. We should not forget that. Okay, extraordinary powers are required to tackle extraordinary situations. But extraordinary powers should be used in positive sense, not in negative sense. The judgment in 2016 by Supreme Court was definitely a welcome step. But let's see how this act or this law evolves. The government itself has said multiple times that we are in favor of reducing it, and the trend before 2023, this happened in Manipur, actually the act was being reduced in areas where it was applicable. The number of areas were coming down. But this happened, so this in Manipur especially, the entire Manipur is now under this act. So this is all about ASPA. And this is it from today's session as well. I will be meeting you tomorrow with Unlawful Activities Prevention Act. We will be decoding it, simplifying it, and be seeing what is the Supreme Court saying about it, what have been the recent cases there. And you can then use these two laws in your answers wherever required. Till then, you guys keep reading, keep studying, keep writing, and most importantly, keep revising. Jai Hind, Namaste.